In each of these matters, Mr. Burrows is here today after failing to appear before this court on June 21st, 2023. In the 2018 case, bond is currently set at $4,086. This is the sixth bench warrant.
Excuse me,
In
sir.
the 2020 case, bond is currently $1,182. This is the first bench warrant. And in the 2021 case, bond is currently $626, and this is the first bench warrant. He reports that he is employed at Franklin Plastics. Last payment made on these accounts was in August of 2022. Front of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on July 19th, 2023 at 8:45 a.m. before this court.
Mr. Burrows, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on July 19, 2023 at 8:45 a.m. You will get notice of that in writing. Yes, sir. What do you have?
Okay, my bond for the failure to appear for this, they sent the mail to the wrong address. They sent it to the address that I'm not supposed to be at anymore.
Okay. So well, they will send it to the last known address that they have on file. If you move, you have to notify the front of the court of a new address, or they will continue to send it to the last address they have.
Yeah, that's what I just did. I had just upgraded all my information because I didn't. Yeah.
Okay. Well, having just did that, didn't get it accomplished before when we had the other hearing. So that's why you're sitting there at this point, because you didn't do it earlier when the hearing was scheduled.
Right.
Okay. Are you able to post a bond, sir?
I'm working. I can pay on it. Like I'm working. Is there a way I can start a payment plan?
Yeah. Well, you have a payment plan. It's called child support. You can pay that, but we don't allow you to do a payment plan on bonds.
I usually I don't have $6,000. So
okay. Well, I'm going to reduce your bonds in hopes that you could be released pending that particular hearing. I'm going to set your bond in the 2018 case. I'm going to set that in the amount of $400, and then each of the other ones, I'm going to set the bond in the amount of $200. So it'd come a total to $600. If you're able to post that, you'd be able to be released. Do you have any questions, sir?
I appreciate you so much.
Okay. Well, you get that posted, but make sure that you come back to the hearing on the July 19th.
Yes, sir. I will.
Okay. 8:45 a.m.
Thank you.
You're free to go, sir.
Your Honor, is it 400 for the 2018 case and then 200 for
100 for each of the other cases.
Good morning,
so total
to
600.
both of you.
Thank you.
I'll start out with you, sir, because you are the plaintiff. What issues do you believe to be in dispute in the case?
I just believe that we have differences and grew apart.
Okay. I mean, are you fighting about in this matter? Are you fighting about custody, parenting time, support, property, death, spousal support? What?
We pretty much have an agreement on all of it, and
okay. Ms. Obrensky, is that your understanding that you believe that you've resolved the issues?
Yeah, I believe so.
I'm asking her, please.
Oh.
Ms. Obrensky, you believe that you do have resolution of the matters?
I mean, I do. I believe that I'm entitled to half of the property. So we have that agreement, but it's not written in stone. Okay, well, you're right. It needs to be memorialized in a judgment of divorce and a uniform child support order. What happens if you do have resolution? I don't want to put in place a scheduling order. A scheduling order is put in place for the orderly progress of the case. Has various dates and things that you need to do and when you need to do those. And one of the processes that is basically initiated with the case scheduling order is mediation. That's where you would go to before an attorney mediator who would
attempt to resolve the issue. There is a cost associated with that. I don't want you to incur that cost if you, in fact, are able to come to an agreement. If you can't come to an agreement, we'll set the matter for mediation. But if you are able to come to an agreement, you should try that first before you start incurring the expenses of mediation. So what I'll probably do is put this in, set this for about 45 days out. And that will give Mr. Obrinsky a chance to prepare a proposed judgment and a uniform child support order. Sir, if you prepare those two documents and send those to the defendant, if she approves those, then again, we won't need to go through with the other case scheduling order and mediation and that process, but you're going to have to get her approval on that, or otherwise we'll have to proceed as a contested matter. Sir, are you working with a service for preparation of your pleadings?
I have a law firm that I'm
Okay.
trying to.
Okay, you can do that, or like work with MichiganLegalHelp.org or some of those services. But in any event, work on getting the judgment. You'll need the judgment, the uniform child support order, and the judgment information form. Those three documents you'll need. The judgment information form would go to the front of the court. The defendant doesn't need that. She'll need to see the uniform child support order and the proposed judgment of divorce. If she approves those, then you can send those into the front of the court, get their approval. And then at that time, we'd be able to complete the case after we get all of that back.
Okay.
Okay. Any questions, Mr. Obrinsky?
No.
Ms. Obrinsky?
I don't believe, so child support, do we need to agree on that, or is that something that the front of the court would determine?
Well, no, what happens, you can agree upon that. And, but there is a, if you get on the site, you'll find that there is a formula for calculating support. And as long as the two of you agree and neither of you is receiving any public assistance for the children, if either of you are receiving any sort of public assistance, Medicaid, food stamps, any sort of public assistance, you cannot deviate from the formula of that. So I don't know if you are or you're not. If you are, you can't deviate, then you have to, basically it'll be whatever the formula states is the required amount. If in fact you don't get any public assistance, then the two of you can deviate from the recommended amount. Does that make sense, ma'am?
Yes, yep, it does.
Okay. And you can get on the front of the court website or any number of websites. So show you can plug in your gross income, number of children, some other factors as well. And then at the end, it'll kick out and tell you what the amount of support should be.
So I don't anticipate that we'll agree on that.
Okay. Well, if you don't agree, then the court will accept whatever the formula requires. So court won't deviate from the formula unless the parties agree. So
okay.
That's something that the two of you are going to either have to agree to, or that'll be the order as to what the recommended is, because there's a ways to deviate, but they're very limited basis for deviation. Okay. Any other questions, ma'am?
No,
Okay.
sir.
Mr. Obrinsky, anything else from you after that?
No, sir.
Okay. Thank you both. We'll reset this, and hopefully in the meantime, you're able to come to some resolution. The court will end this matter at 8:53 a.m. You're free to go. Have a good day, guys.
Thank you.
Thanks.
I left this one for last because we do have a situation. Defendant is missing. The defendant is not present.
Okay. Ms. Stanley, good morning.
Good morning.
Court will note that this matter is before the court on the plaintiff's motion for entry of consent judgment of divorce. We do have friend of the court approval. What I don't have, Ms. Stanley, is I have not yet received the judgment of divorce or the uniform child support order yet from you. Have you forwarded those to the court?
I believe I did. I went in and I have
Well, let me tell you, if you submit them to the front of the court, it's not the same as submitting to the court because the front of the court is separate from the circuit court. Okay, so
Okay.
you have to submit those to the circuit court clerk's office as well.
Okay. Give me 1 second. I believe here in these papers, I did have something that was filed and stamped.
Well, you can try to find those and then let us know if in fact that we'll do is we'll check back with the clerk's office too.
Okay.
You're holding up a paper that I can't read or anything, so you'll have to tell me what it is.
Okay, this is judgment of divorce with children, and I have a stamp on here. It says received April 25th, 2023, FOC reception marked at 1:23
Okay.
p.m.
Again, that's the front of the court's office. That doesn't mean it's filed with the clerk. You have to
Okay, so
file
I
with
have to go to
the
circuit.
circuit court clerk's office for us to get them because all they do is get them so that they can do an approval, which they've done, but we don't get those, okay?
Okay,
So need to file the additional judgment in this case, the Uniform
Okay.
Child Support Order, and file those with the circuit court clerk's office. They will then get them to us, and then we'll be able to enter those and to conclude your case.
all right. I will get them in.
And I'll tell you, if you want copies back from the clerks, make sure you have copies to provide to those because they won't give you copies. You'll have a right to buy copies, but they won't give them back unless you give them copies with a self-addressed stamped envelope.
Understood. I will
Okay?
make sure you do that as well.
Do you have the divorce script with you?
I do. I'm the plaintiff in this case. I married the defendant on November 17th, 2011 at Battle Creek in Calhoun County, Michigan. I filed a complaint for divorce in January of 2023. I live in Michigan for the 180 days and in Calhoun County for 10 days immediately prior to filing the complaint. When I filed my complaint for divorce, all the statements were true. All the statements in my complaint for divorce are still true today. There has been a breakdown of the marriage relationship such that the object of matrimony has been destroyed and there remains no reasonable likelihood that the marriage can be preserved. I do not believe there is any possibility of reconciliation. I am not currently pregnant. The defendant and I have 2 minor children together. Names and ages are all the terms of the proposed judgment of divorce, and I do agree with them. I ask that the court grant an absolute judgment of divorce. Thank you, Your Honor.
Thank you. Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending receipt of the approved judgment and the Uniform Child Support Order. Ma'am, once we have those, I will get those entered. You will be divorced. At that time, you're not divorced, however, until I sign that paperwork. And as soon as you get that in, we'll get it signed and you'll get the case completed. Best of luck to you. I hope everything works out for you. The court will end this matter at 9:06 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Miss Esther, good morning.
Good morning. I just have bench warrants for the record today.
Okay.
So I have 2 people that failed to appear for court this morning, but I have 8 dockets altogether. Requested a bench warrant to issue for each respondent and for bond to be set per statute.
Court would enter a bench warrant for Mr. Jones and Mr. King as a result of their failure to appear on today's date. Court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater. And the court will note, Ms. Hester, that you get the prize today for the most amount of cases for one person.
Look at that. And probably the fastest too, huh?
Yes.
Awesome. Thank you so much.
Yeah,
Case
you have a good day.
2022-27960, yes, Richard Owens versus David Bostatter, Attorney Niels Magnuson for the Establishment Office.
Good afternoon to all of you. Court will note stated appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court for revocation of paternity action. Ms. Owens, are you ready to proceed?
Yes.
Okay. Mr. Bostratter, are you as well?
Yes.
And Mr. Magnuson?
Yes, Your Honor.
Ms. Owens, you can make an opening statement if you wish to do so. Do you wish to do so?
I do not.
Okay. Mr. Bostrader, do you wish to make an opening statement?
No.
Okay. Mr. Magnuson?
No, I would waive that, Your Honor.
Okay, thank you. With that, we'll proceed with proofs. Ms. Owens will take some testimony from you. So, ma'am, in this matter, a petition has been filed to determine that the child was born out of wedlock in this particular case. And what would you like to tell me about in this matter?
Just that I was already aware that what I was told at the beginning of this was that because of the laws of the state of Michigan, and my son was conceived within 10 months of David and I's divorce, that state law required that he was considered to be legal father.
Okay.
And so there was never any question whether or not he actually was my son's actual father. So this has all just been an effort to remove David so that we can pursue action with my son's actual father.
Okay.
And that's all I know about everything.
Okay. I guess, Mr. Magnuson, do you have any questions of the plaintiff?
Thank you, Your Honor. Ma'am, can you hear me okay?
Yes,
There's no doubt in your mind that Mr. Bostatter is not the biological father of the child. Is that correct? Okay.
that's correct.
And you and he did not have sexual relations within the time period that would allow him to be the father, correct?
That's correct. We hadn't had any contact whatsoever for about 2 years before I conceived my son.
And who is the father?
His name is Tim Hall. I actually have him on a case already with front of the court for my daughter.
Okay. And is he in a parent-child relationship with the child? Do they have a relationship?
He is not, no.
Okay. So again, in your mind, there's no doubt that no possibility Mr. Bostatter could be the father of this child, correct? Thank you, Your Honor. I have nothing further.
Correct.
Thank you. Ms. Owens, I just clarify, when you said to Mr. Magnuson that you had not had any contact with the defendant in approximately 2 years, I'll have to ask, was that reference to any sexual contact?
That's reference to any contact whatsoever.
Okay.
Yeah.
Okay. And in this matter, okay, well, I'll ask that with Mr. Bostrader. I'll talk to him about that. So there's no way in your mind, at the time when when Benson was conceived, were you engaged in sexual relations then with Tim Hall?
Yes.
Okay. And was he the only one that you were engaged in sexual relations at that time?
Yes, sir.
Okay, thank you. Anything else, Mr. Magnuson, as a result of those questions?
No, thank you, Your Honor.
Okay. Mr. Bostrader, do you have any questions of the plaintiff?
No.
Okay. Mr. Bostrader, I'm going to have you raise your right hand. We'll have you sworn in and then we'll proceed.
Okay. Sir, do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I do.
Okay. Mr. Bostrader, in this matter, you've heard the testimony of Ms. Owens. Is that, best of your mind, is that accurate?
Yes.
Okay. And you believe, or at least at the time of the conception of Benson Owens, that you had not engaged in any sexual relations with Miss Owens. Is that correct?
That is correct. I hadn't even seen her in years.
Okay. I do note that there had been submitted in this case a DNA test report from DNA Diagnostic Center dated May 17, 2023, signed by Dr. Joy Johnson in this matter. You submitted to that DNA test report, is that correct?
Yes.
As well as the plaintiff and the minor child.
Yes.
Okay. And Mr. Magnuson, have you seen that DNA test report?
I have, Your Honor, and I guess at this time I move for its admission as an exhibit for this hearing.
Okay. Mr. Bostrader, do you have any opposition to that being submitted as an exhibit?
No.
Okay. Ms. Owens, do you have any opposition to that being admitted as an exhibit?
No, sir.
Okay. The court will admit it then, there being no objection. Court would note for the record that that shows, as I stated, the reference was May 17, 2023, that it references samples taken from the plaintiff as well as defendant and the minor child Benson. Probability of paternity of 0% in this matter, and the court, as stated, has admitted that. Mr. Magnuson, do you have any questions of defendant?
No, Your Honor.
Okay. Ms. Owens, do you have any questions of the defendant?
No, sir.
Okay. Mr. Bostrader, do you have any additional witnesses or any other exhibits?
No.
Okay. Ms. Owens, do you have any?
No, sir.
Okay. Mr. Magnuson?
Nothing further as far as proofs, Your Honor.
Okay, thank you. I'll leave it. Ms. Owens, do you have any closing argument in this matter?
I do not.
Okay, Mr. Bostrader?
I do not.
Mr. Magnuson?
I would just ask the court to grant the relief requested. We have the testimony of the parties, which is completely in line with the fact that Mr. Bostrader could not possibly be the father of this child. And also the exhibit that's been admitted confirms that. So I believe there's clearly a basis for the court to grant the relief.
Okay, thank you. Well, the court will find that as well. The court's heard the testimony. The testimony shown for both plaintiff and defendant that they had not had any sexual relations. In fact, they had not had any contact for at least 2 years prior to the date of conception. And as a result, that is confirmed by the DNA test report the court had previously referenced, showing a probability of paternity of 0%. As a result, the court is clearly and convincingly of the understanding that the defendant is, in fact, not the biological father in this particular matter. And court will find that that child born out of wedlock and not issue of these particular parties in this, not issue of the defendant in this particular matter. And as a result, the court will exclude him as a biological child in this particular matter. I don't know. Do we have an order in this?
Yes, I sent it to you.
Okay. Court will enter an order consistent with that, with the evidence and the holding in this matter. That will conclude the case. Good luck to both of you, and thank you, Mr. Magnuson, for your appearance. And you're free to go and have a good afternoon.